Good afternoon, everyone, and thank you so much for joining us today for our event we're calling Religious Schools and Choice After Carson v. Makin. My name is Andy Smarick, and I'm a senior fellow here at the Manhattan Institute. We're here to talk about this important religion and education case that the U.S. Supreme Court is going to hear in less than a week from now. And in just a moment, I'm going to introduce our four excellent panelists. But first, if you don't mind, I'm just going to do a little bit of background on the case itself, but then also explain why years from now, we very well may look back on this case and say that it was the culmination of the court's decades-long reconsideration or maybe even change of mind about the relationship between the government and faith when it comes to schools. Now, just a generation ago, it seemed as though the U.S. Supreme Court had come to a conclusion that the First Amendment required the government to keep its distance from faith-based education. For a century, the court had protected the rights of private schools, religious schools to exist, and for families to choose them. But there were these series of cases across the 20th century that removed just about all vestiges of faith, religion from public schools. For instance, the teaching of the Bible or organized prayer. And then the court went even further, trying to stop, in a number of different ways, public funding from directly reaching faith-based schools. The court at that time believed that public money was going to entangle the government and faith, and the court decided that the First Amendment didn't allow that, so that needed to be avoided. But the court ended up taking a turn, and the famous case Zellman, and this is about 20 years ago now, found that the school voucher program that was at issue was actually constitutional so long as families got the public money as opposed to the public money going directly to faith-based schools. And then the string of decisions much more recently, like Trinity Lutheran and Espinoza, found that if the government is going to run some sort of public program where funds are available to a wide array of different types of organizations, then it's unconstitutional for the government to single out religious schools for exclusion. That is, faith-based schools ought to have a fair shake, a fair chance to participate and even win grants under such programs. So the state couldn't discriminate against an organization simply because of its affiliation with a faith community. But there is this one last question that's lingering, and it's often called the status-use distinction. Perhaps the government can still prohibit organizations from using public funds to advance faith. That's the argument. That is, some believe that even if the government can't stop a religious organization from competing for and winning state money, maybe the government can still prohibit that group from using those funds to advance religious purposes. Under that understanding, the state couldn't put limits on a group because of its religious status, but it could put limits on that group, its use of government funds for religious purposes. In fact, there is this precedent related to higher education. It's from back in 2004 called Locke v. Davey that permitted that kind of distinction, at least in this higher education context. And that's the distinction that's really at the heart of this case that we're here to discuss, Carson v. Makin. So over the next hour or so, we're just going to try to get into the details of this very important case, but also raise some of these important questions and their implications related to the status-use distinction, what the First Amendment, its religion provisions require or allow, especially related to education, and then try to suss out what this means for private schools, religious schools, secular schools run by the government, and also this idea of religious charter schools that people keep talking about. So we have just about the best panel imaginable to help us walk through all of these things. And so I'm going to turn things over to them shortly. First up is Nicole Stelle Garnett. She is a senior fellow here at the Manhattan Institute and the John P. Murphy Foundation Professor of Law at the University of Notre Dame, go Irish, where she is also a fellow of the Institute of Educational Initiatives. Next up will be Michael Helfand. He is a professor of law and vice dean for faculty and research at Pepperdine University's Caruso School of Law. He's a visiting professor and the Oscar M. Rubhausen Distinguished Fellow at Yale Law School and a senior fellow at the Shalom Hartman Institute. Next will be Susan Labadi. She's president of Genius Schools, Inc., a board member of the Council of Islamic Schools in North America, and a faculty member of Consultants for Islamic Schools Excellence. And last but certainly not least is Kathleen Porter-Magee. She is superintendent of Partnership Schools, a network of Catholic schools in a couple different states, an adjunct fellow again here at the Manhattan Institute, and a frequent contributor to our publication, City Journal. Okay, enough from me. Let me turn it over to Professor Garnett. Professor Garnett, if you don't mind, could you just start us off by talking some about the details of this case and then also the arguments you made in your brief to the Supreme Court?
Great. Thank you so much for having me, Andy, and thanks to everyone at the Manhattan Institute for organizing this awesome panel about a case that is very important generally and to me. So a little bit of background. Maine has a program. It's commonly called the Town Tuitioning Program. It's been around since 1873. And the way the program works is if Maine is a state with a rural state. So if you're some of the districts in Maine don't have a high school. So if you're a district without a high school, one of the options you can do is to give the money that you would spend on secondary education to the students, and you give the students the option to go anywhere in the world. So you can go to a private school, a public school, a boarding school. There are kids that went to Swiss and French boarding schools. The one limitation is that you may not attend a school that the state of Maine has deemed to be quote unquote sectarian. So until 1980, interestingly, Maine allowed religious schools to participate in this voucher program. In 1980, the Attorney General issued an opinion that said that it would be unconstitutional under the Establishment Clause to allow them to continue. So they kicked the Catholic and other religious schools out of the program. A number of them closed as a result. And it turns out the AG was wrong. So as you mentioned, in 2002, the Supreme Court made clear that it's perfectly acceptable to allow kids to use public funds in a private school choice program to attend a religious school. Schools that are affiliated with the Council for Islamic Schools in North America, the partnership schools receive funds, public funds to attend. And then this opens the door to really high quality schools to a lot of kids. Maine, although it could allow kids to use their tuitioning funds to attend a religious school, has chosen not to, even after Zellman. It doesn't say that it has to exclude them. It just sort of wants to exclude them. And the question is whether or not it can exclude them by justifying the exclusion by saying we don't want to pay for religious instruction. So last year, in a case that you mentioned called Espinoza, the Supreme Court held that it violated the Free Exercise Clause. It was religious discrimination to exclude schools from parental choice programs because they are religious. The question in the Carson case is this sort of last parentheses. Well, what if the exclusion isn't because the school is religious, but because the school teaches religion? And that's what the Chief Justice in Espinoza and previously in a case called Trinity Lutheran referred to as the status use distinction, or the character use distinction. And so the court didn't actually say there was such a distinction. The court in both Espinoza and Trinity Lutheran just said, look, we don't have to decide this issue because it's clear these schools are being excluded because they are of their religious character. That's unconstitutional. So the state of Maine says, we just don't want to pay for religion. We're not into paying for religion. We're not discriminating against anybody because of their religious status. We're just choosing not to pay for religious education. So as you mentioned, Notre Dame's Religious Liberty Initiative filed a brief in this case. We represented, among others, two of the participants on the panel, Kathleen's, the partnership schools, as well as the Council for Islamic Schools in North America, and a Jewish schools group. And what our brief argues, I think it's sort of hard to debate, is at least in the education context, there is this status use distinction. The difference between being religious and teaching religion is a distinction without a difference, because what it means in most faith traditions, if not all, many faith traditions, Catholic, Islamic, Jewish, to be a Catholic, Islamic, Jewish school is to teach the faith. And to say to the school, you can participate, sure, as long as you don't teach religion, is to put the school to the choice about whether to cease to be a religious school, because the defining characteristic of what it is to be a religious school in many faith traditions is to be fully integrated in, as we would say in the Catholic tradition, faith and reason, to fully integrate the teaching of faith into secular subjects. So the lived reality of faith-based schools proves that this status use distinction not only falls apart, but if the court were to endorse it, and I'm hopeful that it will not, that the states would be free to exclude Islamic, Jewish, Catholic, Methodist, Seventh-day Adventist schools from parental choice programs. Many schools do participate, provided excellent education for the kids, because these schools would simply not be able to put the religion in the corner that would force them to secularize. So that's sort of an overview of what the case is about. And I look forward to further conversation.
Great. Can I just follow up with a quick question? Because one thing we know about this court, especially the Chief Justice, is he's often looking for narrow decisions that don't overturn precedent and maybe don't go too far. Is it possible that there could be a decision in this case along the lines of, okay, you cannot discriminate against organizations because they are faith affiliated, and we're not going to stop these schools from teaching religion. However, you need to account for the use of these government funds, and the use of these government funds need to be used on facilities which aren't related to religion, to desks, to chairs, to Wi-Fi access. What you can't do is use them for religious textbooks or the Bible or rosaries or something else. Is that a distinction that they could draw?
So I think the chances of that happening are approximately zero for a number of reasons. I mean, some of the cases that you mentioned that were earlier cases tried to make those distinctions. So you really got into weird, like you could give schools textbooks, but not maps. You couldn't give them overhead projectors because they might like put a map of the Vatican projected on the wall. I mean, so I just think the court, this is the Establishment Clause context, as you mentioned, one of the things that the federal courts don't like to get involved in sort of the entanglement of policing these kinds of lines. And so I think the question is, that is not a narrowing proposition the court is likely to endorse. I don't think there is. I'd be interested to see what Professor Helfand says. There is a narrow holding here, because basically the court clearly granted this case to resolve the only issue that's left, which is there a distinction between discriminating against a school or another entity because it is religious and discriminating against it because it does religious things. I don't think there's a distinction. I think to be religious is to do religious things. But I do. So I think there are implications outside the education context. There are, I think, a lot of programs, including the Build Back Better program, which has said things. You mentioned facilities. The Build Back Better program says you can't use funds to have religious daycares and religious facilities. So there are other implications that maybe and other kinds of programs where there's like this forcing of segregation of funds. I don't see the court endorsing that here.
Great, thank you. Just a note to our viewers, if you have any question or comment, please use the prompt on the side of your screen to just start to send those questions and comments directly to me. I will get those, and I don't wait until the end. If there's something particularly apt that fits into the flow of the conversation, I will get it in immediately, so do not hesitate to start to send things over the transom to me. Okay, Michael, to you. What are your reactions to the opening and more generally the case?
So, one of the challenges of Carson v. Makin and school choice or religion and state questions as related to private schools, there's a lot of heat when it comes to these issues because of the underlying politics of it. I think there's the public school movement, concern about what this might mean for the public school movement. And, as I started thinking about this case, one of the things that struck me was the need and the importance of considering the implications of the status use distinction outside of the school context. Meaning, let's take a look at this distinction and see if we really mean it. Like, do we really think this is a good idea? The idea struck me, actually. I'm doing construction on my house. Forgive me if you start hearing drilling at some point during this conversation. And, under Jewish law, there's an obligation to put up a fence around a roof. It's actually in the Old Testament. Just literally in there. It has to be, there are restrictions, how high it has to be. And so there's a Jewish law obligation to do it. And in fact, I make a blessing before I do it. I've never done it before. It was super exciting for me. And my contractor, who I love, literally gave me a nail gun, and I started nailing wood into like this deck, and I make a blessing over it. And it strikes me that most people do this anyway. Meaning I think people who have decks, they have fences around it. It would be a terrible idea not to. But for me, it's a religious obligation, one that I make a blessing over because of the way in which it keeps my family and the inhabitants safe. And I started thinking about the way this might work in the context of the status use distinction and government grants generally. You know, there are tons of historic preservation grants, and many of them have requirements attached to them that you abide by certain health and safety codes, which makes a ton of sense. Is the idea of the status use distinction because I would be using government funds in the context of health and safety regulations, I'd be using them for something I deem religious as an Orthodox Jew, that now the government could exclude funding for the fence? And, you know, you start spinning out other implications of the distinction, you know, public-private partnerships for COVID vaccines. In the brief I filed along with the Union of Orthodox Jewish Congregations of America, you know, the Union of Orthodox Jewish Congregations of America, they typically are called the OU. That's easier to say. The OU has issued a press release saying they believe there's a religious obligation to get the vaccine. Well, does that mean at that point that it couldn't receive, or Orthodox Jewish institutions couldn't receive government funding for vaccines because it's a religious use under Jewish law? These implications are kind of startling, and it takes you back to, like, what are the principles that are animating this entire, you know, field of constitutional law? You know, what are we trying to do? In all these circumstances, you're dealing with a government funding program that has secular aspirations, some sort of secular government goal, you know, whether it is to provide schooling, to protect health, to protect safety, historic preservation grants, security grants. And the question is, can a government say, well, because in a particular instance, a particular religious institution is going to use it for religious goals, we can exclude them? Let me say further, actually. In some states, the state constitution would require them to exclude them. Is this what we want in those states? We want to say, yeah, listen, we're going to open up these government funding programs, but we heard you make a blessing on your fence, or you think the COVID vaccine is a religious obligation, so we're required by state law to say, you can't have fences. We're not funding the fence to protect the people in the building or provide the COVID vaccines or to provide security grants because you are a member of a faith that has sprawling, in many ways, expansive views of what religious obligations require and the ways in which you're supposed to use things for religious purposes. I want to make one last point on this front, which is, you know, part of this is like a structural problem in the way in which constitutional law focuses its attention on the kinds of faith communities that live in America. You know, for a constitutional distinction like status use makes sense if you're part of a faith community that primarily sees the lived religious experience through the prism of status. But there is limited opportunity to actually use things for religion. And I worry deeply that the fact that we've come up with this distinction, what has been smuggled in is some sort of majoritarian conception of how religion works. And that other faith communities that aren't as prominent or haven't been as prominent or as big or as powerful, they're not impacting the very kinds of constitutional distinctions we have. So I think it's important, you know, there's so much heat on the school piece of it, taking a step back and asking what are the implications of this distinction and how we got there. You know, my hope is in the brief that we filed, to try and ask us to think through, do we really mean this and how did we get here? And then to return to the question of schools to see how do we want to apply what we've learned in these other contexts to a much more hotly contested debate.
That's great. Thank you. If you don't mind, before I go to the two leaders of schools right now, I want to ask our two lawyers a question that just came to mind. I'm sorry for blindsiding you with this because I didn't tell you I was going to ask you it, but it seems important at this point. What becomes of Blaine amendments at the state level? I mean, Justice Alito wrote a great deal about that, I guess, in Espinoza, and it's been hanging out there since Trinity Lutheran. Is anything left of state-level Blaine amendments if the court comes through and says the status use distinction is artificial, you can't do that, that's not the way it functions? Is there any meat left there? Does the court say something about them or just ignore them, or do they still carry some weight?
So I think one of the reasons, as Michael mentions, one of the reasons why this case is so important is if the court were to endorse the status use distinction, it would breathe new life into the Blaine amendments, which have effectively been limited by Trinity Lutheran Espinoza. So if the court says that you can't exclude religious schools because they teach religion, that will mean that states cannot rely on their Blaine amendments to exclude religious schools. So, but sometimes the language, it will invalidate Blaine amendments get used. And I don't think that's the right way to think about it, because Blaine amendments say different things. And some of them exclude all private schools. So unless you could show that there was an intention of, by saying private, we really only meant religious or Catholic. There's a case challenging the South Carolina Blaine Amendment that makes that argument right now. I think there will be some Blaine amendments. I think definitely Michigan, for example, which just says you may not fund private schools. That's actually not relevant to this, because that's not a discrimination against religion in any way. So it will limit the application of Blaine amendments to the extent they require the exclusion of religious schools, and then often, to Michael's point, other kinds of religious providers. So it's not just about schools. Some Blaine amendments basically preclude the funding of all religious activity, and this would say you cannot do that. But it wouldn't say you couldn't have an expansive Blaine amendment that says we only fund public schools in the state of X.
Michael, any other thoughts?
So I guess, you can kind of think about this question depending on a kind of a little tree diagram of where the court goes. If it embraces the status use distinction, as Professor Garnett said, it'll certainly breathe life back into Blaine amendments. You can almost always recategorize status as use and use as status. I mean, these are semantic games. Am I a yarmulke wearer or somebody who is wearing a yarmulke? I mean, I could be either one. I'm a food eater, or I eat kosher food. I can do this all day. It's super easy. And in fact, even in Carson v. Makin, the fact that they're called sectarian schools that are excluded makes you think it's status. But, federal court said, no, that's use. And at that point, the categories seem just completely fungible. So that would breathe life back into Blaine amendments. On the flip side, if it got rid of the status use distinction, you mentioned this already, Locke v. Davey still hangs out there. Like, is the court going to overrule Locke v. Davey, or is there kind of a third category? There's religious discrimination on the basis of status. You can't do that. Religious discrimination on the basis of use. Maybe after Carson v. Makin, you won't be able to do that. But there will be this third category of Locke v. Davey. There you can still exclude religion. And then the court will have to try to give a description of Locke v. Davey as to why it doesn't fall into the status category or the use category. Maybe it's because of the ancient tradition of making sure government funding doesn't go to help create or teach or something else ministers. Maybe that's what it is. So you'll have status, use, and then a third category of minister stuff. And then the Blaine amendments then would kind of be relegated to minister stuff, and then we'd probably start fighting about what the lines of minister stuff quite capture.
Okay, so I think Locke v. Davey is extraordinarily interesting, but let's leave this as a cliffhanger, because some of our people watching this right now probably don't know too much about it. It's a higher education case, but I want to come back to that, because this third category of higher education minister stuff could turn out to be important, not just at the higher education level, but if the court makes a distinction that there's this third category. So we'll come back to that. But I want to get Susan and Kathleen in here. So Susan, if you don't mind, one thing I find with some people who don't know a whole lot about private schools, much less religious schools, is often they think that religion is a sort of ancillary thing, that maybe you take a couple religion classes or the history of religion. They might not be as attuned to the idea that for most faith-based schools, faith is a line throughout everything: how adults work with kids, how adults deal with parents, what the culture of the school is, what is expected in terms of a code of conduct, and so forth. So you can respond to anything you've heard so far, but also if you could just talk about how in the schools that you work with, how faith permeates just about everything, not just one class during the course of the day. That'd be helpful.
You bet. Thank you so much for inviting me. And thank you also for the question, because I represent over 20 years of working with Islamic schools, first as a teacher, then administrator, providing professional development. I'm a board member with CISNA, which is the Council for Islamic Schools in North America. And basically, we do advocate for Islamic schools. We provide professional development, and we help schools with resources. And in my capacity that I have done several accreditation visits, not just for Islamic schools, but for other parochial schools around the country over the years, I've seen a lot. So here's the reality. Okay, yes, Islamic schools are going to be teaching Quran classes and Arabic classes and Islamic studies classes, but we also have the secular topics of in language arts. We've got math, science, social studies. I was a social studies teacher myself for middle school and high school. And what you find is in many of the schools, because of the lack of funding, frankly, they struggle. And you have teachers who are teaching perhaps 5 different classes throughout the day, meaning 5 different subjects during the day, where perhaps your Islamic studies teacher also happens to be your American literature teacher. So you will find that there is integration of Islam and the culture of Islam in all subjects. That's really what we want to do. And that is in true pedagogy today. You want to be very much integrated. So you find in public schools, for example, you'll have, your math teacher working along with your science teacher, perhaps along with your language arts teacher, with your computer science. All of it works together for the benefit of the students. In our Islamic schools, we typically have our morning assembly where we have a prayer, an acknowledgement, and asking of God to help us get through the day. There is a midday congregational prayer. And for the most part, a lot of the schools, they do participate in intramural sports, and we are not insular. We oftentimes will interact with other parochial schools in sports activities, in competitions, various bowls, if you will. And so this is what we find, that in even our schools, we are part and parcel to a community trying to raise very good, positive identity Muslim Americans. And in this way, we find that a lot of our families are looking to come together to meet other people. We want to be able to have our students in a healthy environment. And you will note too that in our faith tradition, teachers come second to the prophets. So all of our teachers have an understanding, and this is how we get them to do so much work, quite frankly, that the students are a trust given by God to them. And they must do their utmost to bring them up to be very good, responsible citizens.
Thank you. Kathleen, to you, obviously respond to any of this, but also I suspect that all, or at least a high proportion of the teachers of families who decide to be part of your school system, they do it because faith is woven throughout all activities. It's not as though they choose it thinking that faith is just going to be maybe a morning prayer and then you move on, right? So like, how important is the faith component that it is part of your day, it is part of the use of funds to the people who you serve?
I mean, it's critical to I think to school effectiveness more broadly. So we just actually, it's something that we've known and believed and thought for a long time, that you can't separate religion class from like faith formation more broadly. But it's actually something that we looked into even more deeply over the past couple of years. We were trying to understand, like from an accountability perspective, how can we better support our schools and make sure that they are, making good on their promise to serve kids, to form them in character and virtue and values, in addition to teaching them, reading, writing, and arithmetic. And essentially what we came to realize, and what I think research supports and tells you, is that in order to effectively form students in values, in character, and in our case, in faith, then what you have to do is build a school culture that has a really clearly defined mission, vision, and purpose, which for Catholic schools is grounded in our faith and our tradition. And then you have to make sure that everything else that happens throughout the day is aligned to that mission, vision, and purpose. Meaning, your discipline policies, the way, as you said, you interact with the adults in the building. Essentially, you have to live out your faith every day. You have to live out your values every day. And it's only when you're doing that can you have any hope to be forming kind of the whole child, or forming the whole person. And so the idea that you could somehow separate religious instruction out, it's really sort of gutting religious schools of their effectiveness, of their purpose, because the whole purpose in kind of educating and forming the whole person, is making sure that everything that happens throughout the entire day is aligned to your mission, vision, and purpose. So this distinction it not only doesn't make sense kind of intellectually to those of us, I think, in faith-based schools, it also, if you actually tried to actualize it, it would make us ineffective at what we were trying to do.
Right. Can I ask a political question? And feel free to beg off of this if you just don't want to get into the partisan political issues. But often what I hear the most when I'm discussing with elected officials school choice is so many of them will just say quietly, I simply don't want my money, public money, going to advance religion. So is one concern I could have, or that we could have, is that if the court decides to get rid of the status use distinction, that means that all of these public programs not only have to include faith-based schools, but the faith-based schools can use that money for religious purposes. Could that then lead a lot of these state legislators, politicians, State Department of Education officials to be even more uneasy about choice programs? Or the people you work with, is that really not a concern for them? They just want to support public schools, but they like the faith elements of faith-based schools?
I mean, I think what I would say to that, the question of whether you want to support a faith-based school is a question of whether you want to support a school that teaches a particular set of values. And I think that the reality is that every single school in America teaches a particular set of values. So whether you like it or not, public funding is going to schools that are teaching particular values. Whether it is in a public school, like by definition, you're teaching values while it's not defined in the public sphere as faith. You know, what faith is a particular set of beliefs and values. So I guess from a political standpoint, yes, I suppose it would make people uncomfortable, but I think it's, you know, the onus is on us is to make it clear that that again, there is no distinction between these two things. You can't help but teach values. It's not something that just happens in faith-based schools. It's something that happens in all schools. And so right now, I mean, essentially what you're doing is saying we only allow values that we can carve out and define as something other than faith.
Got it. Susan, do you have any thoughts about that in your interactions with public officials, elected officials, state level policymakers?
All I could say really is that all of our schools, we try to encourage them to be active in their communities and to tap into the resources they do get from their districts and have a lot of interactivity between other schools.
Great. So let me now get back to this cliffhanger that I had about Locke v. Davey. And so I'm just pulling this up from one of my favorite websites. It's called oye.org. It has pithy descriptions of key Supreme Court cases. And so in Locke v. Davey, the question that the court was dealing with was, if a state provides college scholarships for secular instruction, does the First Amendment's free exercise clause require a state to fund religious instruction? And by a 7-2 opinion, including this decision was written by then Chief Justice Rehnquist, the answer was no. In the 7-2 opinion, the court ruled that a state does not violate the First Amendment's free exercise clause when it funds secular college majors, but excludes devotional theology majors. The court rejected Davey's argument that the state scholarship program is unconstitutional because it is not neutral toward religion. So with that sort of background, Professor Garnett, do you want to sort of say anything about whether the court can ignore, just move past the Davey case, or if they need to say something and what should they say?
Sure, I'd be happy to. I just one little follow-up on what Susan and Kathleen said in response to your question. I think it's important to keep in mind that 31 states in the District of Columbia and Puerto Rico already have parental choice, private school choice. Only 2 of them, Maine and Vermont, exclude religious schools. So it doesn't seem to be a huge impediment politically. It's changing. I do think it would be a concern if the court were to sort of endorse the opportunity to exclude religious schools. That would be put one belief, one faith, one belief tradition, and only one off the table, which is faith. So that's a concern given the footprint of school choice in the U.S. So Locke versus Davey actually didn't, at least as most law and religion scholars read it, is it was about the funding, as Michael said, of ministers. So it was devotional theology. Joshua Davey, who became a lawyer, not a minister, was studying to be a minister at a college, and he was told by the state of Washington that he couldn't use some merit scholarship that was funded by the state of Washington to pursue a degree in ministry. You could attend a pervasively religious school with such scholarships. You could study theology. You just couldn't become a minister. That was, and the opinion can be read sort of narrowly as being about minister stuff, as Michael said. I think it's easy to read it that way in Carson and make it go away. Like that's just minister stuff. Then we can later have fights about what minister stuff is. It could be read more broadly as to be about religion stuff. But I think it's really, the Chief Justice took care in these cases, especially Espinoza, to say that was really about, not funding ministers. And there was a long tradition of not funding ministers, but it's different when we talk about religious schools. So I think it's easy to cabin, and
interestingly,
the parties have not asked to have the court overturn Locke versus Davey. There are a couple of things that I would just point out that make this case very different than Locke versus Davey. The first is that Washington hung its hat in that case on its Blaine Amendment. It said, you have this establishment clause that's much stricter than the federal establishment clause, even though this would be okay. Our state has a tradition of not getting too entangled with religion up to the point of funding ministers. Maine doesn't have an establishment clause at all. And the other is the court makes a big deal in Davey about how, well, we have a tradition of not funding this stuff, a long tradition of not funding this stuff. There's no such tradition here because Maine was actually tuitioning kids to religious schools as of 1980. So I think it's easy to not overturn it. I think the court will not be inclined to overturn it because it hasn't been asked to. I expect there'll be a concurrence or so saying that they should overturn it. But I'm interested to hear what Professor Helfand's thoughts about Locke versus Davey are.
Well, why not be candid? Locke v. Davey's a mess of an opinion. I mean, it strikes me as a train wreck. It always has. I mean, there are some comments in Locke v. Davey authored by Justice Rehnquist that, when I teach it, and you read through the footnotes and some of the justifications, it just seems bizarre. So there's this one comment that, I was actually just pulling it up on my other screen over here, just like this is the sentence that kind of drives me nuts in the case. The court, part of what it hung its hat on is the following sentence. And it, meaning this exclusion of scholarships for degrees in devotional theology, does not require students to choose between their religious beliefs and receiving a government benefit. Now, this was a puzzle over here because, had you asked Joshua Davey, who I believe represented someone and filed a brief in Carson v. Makin, I want to go back and check that, but I believe that's true. I think I saw that at some point. I got let out a little chuckle. And, you're wondering, wait a minute, I think it is making him choose because if he pursues his degree in devotional theology, then he loses the government benefit. There's this funny little footnote. The footnote says the following: promised scholars may still use their scholarship to pursue a secular degree at a different institution from where they are studying devotional theology. Almost as if to say, no, Joshua Davey, you still have access to this thing. You can enroll in the second school simultaneously. And you're kind of like, I think you've missed the point of what I'm trying to do, which is to go to the school and pursue a degree in devotional theology. The fact that, that language actually made its way into Trinity Lutheran a little bit in kind of subsequent cases, this idea still that whatever the exclusion is, it can't put applicants to this sort of choice. And it just seems to run counter to the underlying logic of Locke v. Davey. So I've always thought it's a bit of a mess. Once it tries to maintain that proposition and tries to kind of gerrymander in bizarre ways what a student might want, maybe you still have access to this thing. You can enroll in 17 different schools and maybe collect all the cash. That seems weird. So I've always thought it's a mess. Now, I think Professor Garnett is certainly right. I would be shocked if they overrule Locke v. Davey. And part of this is, of course, I think because of the heat on the court generally. I think, yesterday we heard oral argument in an abortion case. You really wonder at a certain point how much in terms of overturning precedent or, where's the court going to kind of place its chips. And so I'd be blown away if they overruled Locke v. Davey. My gut is, Justice Gorsuch has pushed this line of reasoning that it's really about traditional minister stuff. And maybe somehow, that ends up winning the day, just trying to cabinet based on its facts into some sort of other bucket that then gets hashed out at a different point in time. But at least that's my instinct about how this, if the court ultimately does strike down or try to eliminate the status use distinction, what it ends up doing with Locke v. Davey.
Thank you. We're getting a bunch of good questions from the audience. I want to encourage more people to send them in, and I will work them in a second. But I wanted to turn to, again, Susan and Kathleen, and you can choose which of these to answer. But it seems to me that upholding this Maine program, allowing the faith-based schools to be included, it seems like not only would it have practical implications for schools, so if you want to talk about that, like what does this decision, if it comes down in favor of faith-based schools, what does it mean for your schools? But it also seems like it could have symbolic value, that for a long time, a lot of these decisions going back, I don't know, to the middle of the 20th century, seem to put religious schools off to the side. That suggests that they were others in important ways, that they were doing something that the public just couldn't get behind. And things started to change with the Zellman case and then Trinity Lutheran and so forth. So is it just important to your schools for the Supreme Court to say, listen, faith-based schools are a part of our fabric and they need to be treated just like every other principles-based school, and faith does not need to be excluded? Like, do you feel a symbolic value in the court making the right decision that is going to influence the way you and others think about your schools?
I think for us at Partnership Schools, I think the greatest value, because we run Catholic schools in both New York City and Cleveland, Ohio. In Cleveland, Ohio, our students do have access to vouchers and tax credits. So it's obviously a very different landscape. In New York, we have no access to public funding in the form of tax credits or vouchers. And it's also a Blaine Amendment state. So I think for us, they will have a huge impact on our work, but more because of the path that I would hope it might clear for future access to public funding. I don't think, in terms of like the activities taking place within the four walls of our schools, I don't imagine it would have an impact unless it cleared the path to public funding for the schools we serve, the students we serve.
Do you feel like there is a cleared path? There have been, especially during the pandemic, more and more public opinion surveys showing support for things like education savings account, more families saying that they want to have more choices. New York has tried to pass a school choice legislation for eons, it seems, and always comes up a little short. Does it feel different now?
I don't know the politics side of this in New York City. I suspect from purely a question of politics, I suspect in New York, it is probably almost as hostile as it has ever been. I hope that the movement that's happening nationally, and I suspect it is having an impact on the environments in New York. I know on a very practical level what we're seeing. So one of the things that we did at Partnership Schools in New York City specifically during the pandemic was we changed our enrollment system. What we realized is that funding was not the only barrier to entry for low-income families. And so what we tried to do is streamline our scholarship programs, the amount of paperwork we required, everything else, in order to make sure we were serving as many families as we could. Through doing that, a combination of the fact that we were able to effectively serve students and communities during the pandemic, and also that we worked so hard to reduce barriers, we saw a dramatic increase in enrollment in our schools this year. So our enrollment overall in New York increased by about 15%. In particular, we saw an 11% increase in the number of poor families who are coming to our school. And I say that to say, I think that I am hopeful that what people, the national conversation and how people are becoming more and more open to choice programs, I'm hoping that will have an effect, because what we are seeing is that families in New York City really want to, or in New York more broadly and in Blaine Amendment states across the country, really do want to capitalize and are really being held out. These barriers to entry are preventing them from making the choices that they want on behalf of their children.
Great.
Us similarly, I think that, we're looking at free market education here. We have the opportunity so that many of our schools, by the way, like our tuition for many of the Islamic schools runs like $6,000, $7,000, $8,000 a year is what we're charging our parents. And granted, there are some families that they're able to help in giving scholarships, but at the end of the day, most of our schools are running in the deficit until they get to the annual fundraiser. That's always a struggle. So what we would hope for is that you're going to find more students coming into the Islamic schools. If that is, in fact, the best choice that people feel they have, you'll also find that the parents who have been struggling and burdened with not only paying their tuition for their Islamic schools, but also through their taxes paying for their public school system, will find that their students are able to get an equitable education.
Great. Let me ask a question that's come in from the audience, which is, it relates to what counts as religious. So the question is, could it be argued that some of the topics and principles taught in public schools are themselves religious or quasi-religious? That is, even if they're not faith-based, even so, that is, they don't fit into the traditional definition. So I think what this question is getting at is, just about every school has a curriculum, has a set of views about what is right and wrong, and like how to build students. So how do courts distinguish between what counts? I mean, if a classical education school is not considered religious because it's secular, it's still religious in the sense that it is firm and these rules and a way of thinking about the good life and so on. So is there a definition for what constitutes faith-based religion or what not?
It's a very good question. When I think about, even in our schools, several of them, they will teach the Bible as literature. When I was teaching both English literature as well as social studies, we look at the early days of, what was the Quaker religion about. So this is something that you would also find in a public school system as well, I would expect.
Yeah.
Go ahead, Kathleen.
No, I was just going to say, I agree completely. I think it goes back to the question of it is impossible to not make choices about teaching values if you're going to be, I mean, we are all forming, future citizens. Schools teach about right and wrong and the choices that they make. And we see this in some of the fights that are happening in public schools right now. The choices that public schools are making about what to teach and explicitly what not to teach are values driven. And again, I think the distinction that people are making when they talk about religious schools is schools run by established churches. It's not about whether schools teach values, because they all do.
I mean, I think legally, though, it's important to point out that the status use distinction doesn't apply to public schools. I mean, so that you could make arguments that there are things that get taught in public schools that are quasi-religious, but I think courts make quite clear that it's not interested in those arguments. I think the real question is what Kathleen says. And this is a debate about whether you can exclude schools because they teach things identified as religious, not because whether or not, like, because the public schools sometimes teach things that have devotional or ideological components, they have therefore been transformed into religious schools. That question is not on the table.
Michael, any thoughts on this?
Oh, happy to chime in, but I think everything that needs to be said has been said. I would also note that, like, once you start expanding the scope of what counts as religion, at least, each time you ask a question like that, you have to ask the definition for what purpose, meaning why are we asking what counts as religion? And for a lot of the legal questions, if you start expanding the scope, you begin to wonder, is everyone then now, all these institutions, do they qualify for protections under the First Amendment, the Free Exercise Clause, religious discrimination? Like, there would be a lot of very counterintuitive consequences if we started applying, at least for legal matters, the category of religion to all these other contexts. The court's always worked with kind of an intuition and no definition as to what religion is. We kind of know it when we see it. I suspect that's, as Professor Garnett said, that's where we are to stay.
Great. We only have about 10 minutes left. Do our lawyers want to say anything about this concept of religious charter schools that keep?
So I know, I see Andy's breaking up. I can jump in because I've talked about this before. One of the things that's quite clear in the cases that come before Carson and even in Carson is that one option that the states have is to simply not fund private education. So if Maine loses in Carson, it can simply say we're not tuitioning anymore. And it might. There's only a few thousand kids that are getting tuitioned, and I think that would be unfortunate, but they can choose to do that. And Justice Roberts says in Espinoza, the state need not fund private education, but if it chooses to do so, it cannot discriminate on the basis of religion and excluding schools. Justice Breyer in his Espinoza dissent says, what about charter schools? And the reason he asked this question, I think it's a good one, is the question really is, so charter schools they must be secular, they're called public schools, and they're privately operated. So does the private operation turn them into a system of private choice instead of a public school system. If the charter schools are government schools, if they're public schools, as the way we typically understand schools as being government schools, then it's clear they may not be religious. And if they're private schools, then maybe they can be religious. And then the natural next question is must they be permitted to be religious? Many states exclude not only religious instruction in charter schools, they exclude religious operators in charter schools, and so I think those questions, like the Espinoza is really relevant to that question, but there are other underlying questions, and the main one being, are charter schools public or private? And does the fact that the state designates them as public, but they're privately operated, what does that mean? How does the law, federal law, deal with that question? Interestingly, the Fourth Circuit just ruled not too long ago that charter schools in South Carolina were private. Not in a religion context, actually. The case involved a challenge to a dress code policy that required girls to wear skirts. It was an equal protection challenge, gender discrimination challenge. And the school defended itself. It was a classical school. It defended itself saying, well, we're a private school, not a public school. And the Fourth Circuit agreed. So to your question, Andy, if the Fourth Circuit's opinion were to hold and it's actually being reconsidered by en banc, then it really would open the door to religious charter schools. But that's not that question won't be resolved in Carson. There's like there's several layers before we get there.
Great. We only have a couple of minutes left, so I want to give everyone a chance to say final words if they'd like. So, Susan, do you want to go first? Anything we didn't cover or anything you want to underscore as we're closing up here?
I just want to thank you. It's been a fascinating, thought-provoking conversation. I truly appreciate it. And I really hope that things will go in favor of school choice and the ability for our schools to get benefits that are sorely needed. Thank you.
Thank you. Kathleen.
Here. Again, it was great to be here, and especially hearing the legal and the constitutional sides of the argument. And I appreciate just the opportunity to chat about this, and I do hope it paves the way for greater choice.
Michael, what did I forget to ask?
Absolutely nothing. But I did want to note the following. There's been a lot of conversation about, status use distinction goes away. What does it mean for the politics? I think one of the most important things that advocates in this area can do is try to remind politicians, when you open up these government funding programs, it's because you have some sort of admirable goal. There's some sort of secular purpose you have that you're trying to accomplish. You're trying to provide education. You're trying to provide, as I said, think about it outside of schools, provide security grants. There are all these things, laudable things you're trying to do. The idea that, you'd worry about, some consequences down the road when ultimately the funding program is targeting opportunities to promote this secular goal of yours strikes me as, you're cutting off your nose to spite your face at that point. And, redirecting people to think about the core goal of funding programs, which can't just be to advance religion. It's something bigger than that. And we just want religion included on equal terms. I think that has to be at the very center of what advocacy looks like, if Carson v. Makin ends up striking down the status use distinction.
That's great. And Professor Garnett, say whatever you want, but one thing that maybe to close on, if you have thoughts, is it is striking that over the past generation, the court has, if not done a 180 on a lot of these religion and education classes, they've turned on them. So if any thoughts on just how this case fits into that broader theme and why it came about and what it means for the future might be helpful for some of our viewers.
Yeah, I do have, I'll close with a thought about sort of following on what Michael just said and what Susan and Kathleen said, but I do think there is, the court has come full circle. I don't know if that's the right way to say it, but I mean, we have moved from a world of, in the Establishment Clause world, a world of hostility to religion, to a constitutional order beginning in the 40s with a case called Everson, which basically said, the Constitution is hostile to religion, that what is required is not neutrality toward religion, the exclusion of religious providers, particularly schools, and a kind of fear, I think, of religious instruction. a fear that was born of bigotry, unfortunately, and has a very, very deep and unfortunate roots in the United States. A fear of the word sectarian, my husband, who is a law and religion scholar, likes to say, the word used by the state of Maine, sectarian is a dirty word for somebody else's religion. It's a dirty word for religions that are dangerous, minority religions, Catholics, Muslims, Jews, and into embracing fully really the wonderful pluralism in civil society, and embracing this rule of neutrality, which says that it not only is the Constitution not hostile to religion, it's welcoming toward religion, and if you're going to fully embrace and try to advance these public goals through public-private partnerships, then you can't say you're not welcome because you're sectarian. And I think that it is really a powerful and moving thing. And the last thing I will say, as a powerful moving thing to me as a convert to Catholicism and a lover of Catholic schools, the arguments that are being advanced in Carson versus Makin have been advanced by the Catholic Church in the United States for over 175 years. The first Archbishop of New York, a man whose name was Dagger John Hughes, for a variety of reasons, and he enjoyed that name. He fought the public school funding authorities to get money for Catholic and Jewish schools in the 1850s on equality grounds, saying we're serving the poor, providing a good education. And mostly these are Catholic schools. There were a few Jewish schools in the place, but they were like, so we should, and to exclude us is bigotry, born of bigotry and discrimination. And so it's very moving to think about all these years later, we're poised for the Supreme Court to vindicate that proposition, that our polity, our pluralistic polity, welcomes and fully embraces all religions. And the other thing I would say finally is just, if you're a student of education policy and you're honest, you know that faith-based schools just do a really, really good job, especially of serving the least among us. As we like to say in Catholic schools, I think in part to say something that Kathleen has mentioned, has said, I've heard her say before, one of the reasons that Catholic schools succeed is because we believe that children are made in the image and likeness of a loving God, and therefore we have a duty to bring them to their full God-given potential. Catholic schools, Muslim schools, Jewish schools, Protestant schools, if you look at the evidence for the effects of these schools and the lives of real people, they've lifted generation upon generation out of poverty and transformed their lives and made them into good citizens. And I think it's an education policy that excludes them it's not just unjust, it's foolish. And so the court will be wise to embrace the elimination of this half category of status used to enable these schools represented by folks like Susan and Kathleen to fully participate in the sacred duty and the sacred task of educating the next generation.
Well, thank you so much. What a powerful way to end. And thank you to all of our guests. Let me just close up here so I can get you out by 2 p.m. as promised. This has been terrific. I just invite everyone who is watching to please browse the Manhattan Institute website, check out our research, subscribe to our newsletters. If you're able, consider making a contribution. We are a nonprofit organization, and we depend on support from folks like you. So thank you to all of our guests, for the back-end people who are helping make all this possible. And I'm sorry I've been glitchy, internet problems, but I appreciate all of your time and efforts on this. And we'll watch the arguments in about a week from now. Thank you.
Thank you.
Thanks.